All right.
All right, members. Everyone, thank you for being here for the full Judiciary Committee. Madam Clerk, you go to open the board. Members, let's get punched in. All right, it looks like everyone that's here is signed in. All right, Madam Clerk, you take the roll, please.
Mr. Chair, you have 18 members present. You have a quorum.
Okay, very good. Members, any personal orders or announcements before we get started? Members, anybody? I'm scanning too. Surely somebody has somebody to recognize. All right, let's get started. Just a couple of housekeeping issues. We have item 7, that's House Bill 2279 by Leader Cochran, requested to roll that for 1 week. Any objection, members? All right, seeing none, roll for 1 week. That's House Bill 2279. And also, members, without objection, item 38, that's House Bill 1971. And that's my piece of legislation there. I'm asking that be rolled 2 weeks. Any objection? All right, seeing none, rolled for 2 weeks. And that brings us to our calendar. Members and folks, we're going to be jumping around the calendar today. We've got some things that kind of got behind on last week. We're going to kind of catch up. But we're going to go ahead and start with item 1 by Speaker Zachary. Sir, you got a motion to second. That's House Bill 1971. I don't see an amendment. Is there something? You ready?
No amendment. No amendment.
All right, you got a motion to second. You're probably recognized.
Yes, sir. Thank you, Mr. Chairman Committee. Members, I'm carrying this on behalf of the Attorney General's office. This legislation clarifies and expands the state's rights to immediately appeal to the Court of Appeals certain interlocutory trial court orders that significantly affect the state's authority and legal protections. This simply aligns us with federal code. This is a process the state is able to take now in federal court, and this simply aligns that on the state level. I'll be glad to answer any questions. And Mr. Chairman, if we may, because I know the Attorney General's office did send Mr. Alan Groves to testify on this bill, and I believe he did sign up. And I think they wanted to speak to this briefly and answer some questions. So if you would mind, we could go out of session if he had signed up to be able to hear from Alan.
That sounds good. First, we ask members, do we have any questions from the sponsor on the bills? Any questions? Okay, okay, very good. All right. Sounds like we want to hear from our speaker that signed up. That he has. That's Mr. Alex Groves. So members, any objection going out of session here from Mr. Groves? All right, seeing none. We're out of session. Mr. Groves, you would just come up here, have a seat. Be sure your microphone's on. You can pull it down close to your face there so we can hear you. And you'll have 3 minutes. And after that 3 minutes, you'll have time for questions. And you're recognized.
Good afternoon, Mr. Chairman, members of the committee. I probably won't use my whole 3 minutes because I'm happy to answer just whatever questions you might have. But as Representative Zachary mentioned, this bill really just clarifies and expands the state's right to appeal in 3 narrow circumstances. One is when a trial court issues an injunction against the state. A second one is when a trial court denies the state's assertion of sovereign immunity or public servants' assertion of qualified immunity. And the third would be the denial of a motion to dismiss. And the reason that we're asking this body to pass this legislation is just simply to make state government more efficient, because some of they're really all threshold issues that will arise at the beginning of a case. And if the state is allowed to appeal from an adverse decision early on in the case, it allows all parties to have more clarity and certainty about what issues to focus on when you get the guidance from the appellate court. Right now, we have to go to a trial court most of the time to ask for permission to appeal some of these threshold issues. And if the trial court grants that motion, you would then go to the appellate court to again ask permission to appeal. But some of these issues are issues that you would really want to be decided early on in the litigation, such as whether the court even has subject matter jurisdiction over the case. If the plaintiff filed in the wrong court, for instance, that would be something that all sides in the case would want to have decided before you go through the burdensome process of discovery, trial. And those things simply take a lot of time and effort and money that taxpayers are ultimately on the hook for. And we're asking to be able to appeal some of those types of issues to the higher court earlier on in the litigation so that we can get the clarity that we need so that the case can proceed efficiently. But I'm sure you'll have questions for me, and I'm happy to answer those.
Very good. Members who have any questions for Mr. Groves? Representative Johnson, you're recognized.
Thank you, Mr. Chairman. For the AG, who do they represent? Do they represent the state or do they represent the citizens? Where does the loyalty lie?
So the Attorney General represents the state of Tennessee in most cases, and also public servants who are serving in their official capacity.
So you said that normally you would have to go to trial court. So for regular citizens, for the rest of us, we've got to go to trial court. We've got to have discovery. We've got to prove something before we can get an appeal. This is giving a fast track. It's creating a two-tier system so that the state AG has special privileges to bypass all of that other and can tie someone up in court for years with all these appeals before anything is even given in discovery or anything else. Why does the AG feel like he's not able to handle these cases, or why does he need these special privileges for bypassing the system that the rest of us have to use?
Sure. There's a few things in there that I'll address. Number one is that, again, this only applies to 3 different categories of orders. So we're not talking about any type of order. One of those types of orders is an order denying sovereign immunity. So obviously only the state is going to have sovereign immunity, or only a public official is going to have qualified immunity. So that's not something that can really be applied to a private citizen. Now, with respect to injunctions, Tennessee law already allows the state to appeal from certain types of injunctions. So this law is simply clarifying that it applies to all injunctions and not just cases where there's a constitutional challenge to a statute, but if there's an executive order or an administrative rule, it also apply. Now, for motions to dismiss, private citizens actually do have the right to automatically appeal certain types of motions to dismiss. The Tennessee Public Protection Act, which is our anti-SLAPP law, if a private citizen moves to dismiss a case because they think a lawsuit has been filed against them in retaliation for them exercising their First Amendment right, Tennessee law gives that private citizen a right to automatically appeal if the motion to dismiss is denied. So there are certain instances where a private citizen could also have a right of appeal. But in general, it's important that the state have a right of appeal from these types of threshold issues, because if a case has to go to final judgment, that burdens all Tennesseans, not just the governmental actors that are in charge of enforcing state laws. Because when a department or an agency is tied up in litigation and discovery, they have to comply with litigation holds, they have to preserve documents, they have to attend depositions. And every hour that's spent on discovery or document review or trial prep is an hour that state officials could be using to provide essential governmental services to all Tennesseans. So I think everyone benefits, taxpayers benefit when we have an efficient appellate process.
Yeah, I think a bigger benefit would be not doing things that are unconstitutional so that these challenges happen. I mean, most of us can read the Constitution and understand what it says and not violate it, but it seems like a lot of time up here we're passing lawsuits instead of legislation. And so the reality is this gives the AG a path that other folks don't have, and it gives them ability to tie up a regular citizen in court for 3 to 4 years. And most people can't afford that. billion-dollar corporations can afford that, but the average citizen can't.
And Representative Johnson, I have heard this raised in previous committee meetings where there might be this endless appeal process. And I would be concerned about that too if that was what this bill did, but it really doesn't. And that's because a Rule 12 motion to dismiss is something that's filed at the very beginning of a case. It's when a party is going to raise all of their affirmative defenses. They're going to raise the issue of sovereign immunity. And then once that gets appealed, the appellate court decides those issues. And if the state wins, it would go back down, but the parties would be bound by the appellate court's decision on those issues. So we are not able to relitigate those issues. You couldn't take multiple appeals from that decision because we're all bound by the appellate court's decision. And an injunction, similarly, you're only going to have a temporary injunction or a preliminary injunction at the very beginning of the case. So if that gets reversed on appeal, there's not really like subsequent appeals that we would be able to take from that.
I do understand what you're saying, but I can tell you that every judge and every lawyer that I've talked to has told me that it will do this and it will cause this to happen. But I appreciate you answering my questions.
Sure.
All right, members, anyone else before we go back into the session? I have Representative Doggett, you're next.
Thank you, Mr. Chairman, and thank you for being with us today. You said that there were some instances or circumstances where a Tennessee citizen could have an opportunity for automatic appeal. You listed one. Are there any others?
That's the main one that I'm aware of is the Tennessee Public Protection Act, which involves, and again, the reason why is because a private citizen is asserting that a lawsuit was filed against them in retaliation for them exercising their constitutional rights. And this bill similarly applies when a private citizen is challenging the constitutionality of a state law or an administrative order or some other governmental action. So that is, I think the reason why it's narrow is because there's that constitutional issue involved, if that makes sense.
Chairman Doggett.
Thank you. Think about an instance where, a citizen is challenging maybe they're challenging a statute that's on the books for constitutionality purposes, and maybe they get to court and it's the case is dismissed, and there's the motion dismissed by the state, and they dismiss the case. The citizen at that point they do not have the opportunity for appeal, but under this, the state would, if they filed the motion and they were denied in the court, they could appeal to the Court of Appeals to take another stab at it. Is that what I'm understanding?
Well, if the court grants a motion to dismiss and it results in a final judgment, then the plaintiff would have the automatic right to appeal under Rule 3 of the Rules of Appellate Procedure.
Even in one of those instances where they're challenging a statute, the citizen themselves would have the right of appeal at that automatic right of appeal. Is that?
Yes, if there's a final judgment dismissing the case and there's no other claims outstanding, there's an automatic right of appeal under the Rules of Appellate Procedure, not under the statute, but under the rules of procedure.
And when you say right of appeal, that means that they would have to exert that, or is that the same way this bill is? We're talking about an automatic appeal where could you explain the difference?
Sure, I understand. When we say automatic right of appeal, we really mean you have the right to appeal. You don't have to ask a court for permission, but you still have to exercise that right by filing what's called a notice of appeal with the appellate court. That's how you initiate the appeal. But it doesn't just happen automatically without you taking any action. So the automatic is a little bit of a misnomer in that sense.
And under this bill that's before us today, if an individual brought suit against the state makes maybe a motion to dismiss, it's denied. So then that kicks in this automatic appeal to the appellate court. The court then issues that motion to dismiss. What recourse does the citizen in this instance have going forward?
Are you asking if the Court of Appeals rules in the state's favor?
Correct.
Then the case would go back down to the trial court, and then the case, if the Court of Appeals rules in the state's favor and grants the motion to dismiss, the case is over. And so then the private citizen would then appeal as of right if there's a final judgment dismissing the case.
And they would appeal to?
The same court.
Okay.
The Court of Appeals. And it is important to remember, too, that just because the state has the right to appeal in these cases doesn't mean that we're automatically going to win the appeal. And so it's not taking any judicial power away from the courts. It's not taking citizens, right to have a decision on the merits. It could be that the trial court issued a correct ruling, but that when the state appeals, everybody gets a decision from a higher court in a quicker manner, which gives all the parties clarity about how to proceed.
It's my understanding that this is somewhat modeled after what is standard procedure in the federal government. Does that sound correct?
Yes, partially. Under federal law, the government can appeal as of right from any injunction, a preliminary injunction or a permanent injunction, and it can also appeal as of right under the collateral order doctrine if there's a denial of sovereign immunity. So those are the ways that it's consistent with federal law.
What extra are we doing here? What's in addition to what is done in the federal law?
The motion to dismiss aspect of the bill,
Okay.
that would be different.
Thank you.
President Powell, you still have questions, sir? If so, you're recognized.
Thank you. I do. So I know, so it's following your testimony. One is you referenced one state sovereignty.
Mhm.
And you said there were three. So the other two are, for
So
clarity?
when a trial court grants an injunction against the state
Okay.
is the first one.
Okay.
The denial of sovereign immunity or qualified immunity is number two. And then the third is the denial of a motion to dismiss.
Okay. And I guess too, can you speak to because this was brought up in a question, if a law is found to be blatantly unconstitutional, it still survives challenges. I know in the past I've submitted attorney general opinions and not heard back, and I know some of my colleagues have too. So I think that would create a lot of legwork on the front end. If the attorney general's office would opine on unconstitutional laws, it would avoid this entire process completely. So just commentary on that. Thank you.
Members, anyone else have any questions for our guests? All right, seeing none, any objection, going back into session? All right, seeing none. All right, back into session. First on the list, I have Representative Travis. Sir, you recognized?
Thank you, Mr. Chairman. I'll call previous question.
All right, previous question's been called. This proper motion, proper session, and we have plenty of objection there. So members, that's more than three hands are on the board. All in favor? Madam Clerk, if you open the board, members were voting on previous question. All in favor of previous question, vote aye. All opposed, vote no. As every member voted, any member will change the vote. All right, Madam Clerk, if you would, just take the vote.
Mr. Chair, you have 13 ayes, 5 noes, and 0 present not voting.
Very good. Previous question prevails. Members were now voting to send House Bill 1971 to calendar and rules, 1791 to calendar and rules. All those in favor, Madam Clerk, if you'd open the board for voting, vote aye, opposed, vote no. Every member voted. Anybody want to change the vote? All right, very good. Madam Clerk, take the vote, please.
Mr. Chair, you have 12 ayes, 6 noes, and 0 present not voting.
Very good. Congratulations, Speaker Zachary. House Bill 1791 is moving to calendar and rules. Thank you. Yes, Representative Johnson, you're recognized.
Wouldn't it be nice to allow debate for folks?
Okay. And I agree. That is an improper question with regards to a point of order. So members, now we're moving. Now, like I said, we're going to be hopping around a little bit, folks. So if we could, members, let's move to item 33. And we're not going to do that because Representative Doggett is not in here right now. So let's move down to item 31. Chair Lady Littleton. That is, and members and folks, that's House Bill 2083. You've got a motion and a second, and there's no amendments on this bill that I'm aware of. You're probably recognized.
Thank you, Mr. Chairman. This moves the age from 3 to 5 for the safe baby court. Right now, they're allowed if they're 3 and under, so we're just raising that to 5 to put them into the safe baby court.
Okay. Thank you for that explanation. Members, any questions for Chair Lady Littleton? All right, seeing none, any objection to the question? All right, seeing none. All right, all those in favor of sending House Bill 2083 to calendar and rules, vote aye. Madam Clerk, if you'd open the board for voting. All those opposed, vote no. Has every member voted? Anybody would like to change their vote? All right, Madam Clerk, if you take the vote, please.
Mr. Chair, you have 18 ayes, 0 noes.
Very good. House Bill 2083 is moving to calendar and rules. Now, if we could move to item 33, Chairman Doggett, we had, that's on House Bill 369. Sir, you got a motion in a second. I'm looking at House Amendment 12764.
Yes, sir, that is correct.
All right, you got a motion to have a
Second.
second. You got a motion on amendment and a second. Members, we're going to go ahead and put that amendment on. Chairman Doggett, does that reroute the bills? It
Yes, sir, it does.
makes the bill. Members, any objection to adopting House Amendment 12764?
Well, I'm sorry, it does not make the bill, but it kind of does.
Would you like to explain it?
It's the effective date change. I'm
It's an
sorry.
effective date change.
Yeah.
It's an effective date
So it
change.
kinda
Any
makes it,
objection
but it
to
kinda
adopting
don't.
House
Yeah.
Amendment 12764 to House Bill 369? All right. All those in favor say aye, opposed say no. Ayes have it. All right, now we're back on the bill as amended, sir. You're probably recognized.
Well, thank you very much. It just clarifies, members, that a school employee does not commit the offense of falsifying educational and academic documents for changing grades in a credit recovery program that a student would go through.
Very good, members. Any questions for Chairman Doggett? All right, seeing none. Any objection to the question? All right, seeing none. Madam Clerk, if you'd open the board for voting. Members, all those in favor of sending House Bill 369 as amended to education, full, vote aye. Those opposed, vote no. Has every member voted? Any member like to change the vote? All right, Madam Clerk, if you take the vote.
Mr. Chair, you have 19 ayes, 0 noes.
Very good. House Bill 369 as amended is moving to education. And if we could, members, if we could move to item 24 and 20, no, actually, let's move to item 34. 34. Representative Ashley. That's House Bill 1871. I don't see any amendments, sir. You're probably recognized.
Thank you, Mr. Chairman. This bill requires a person convicted of second-degree murder to be punished at a range 2 as a range 2 offender. Allows a person to be sentenced as a range 3 offender if appropriate. This bill is brought by the DA's conference, and we have someone here to answer any questions if need be.
Very good, members. Do we have any questions for Representative Ashley? All right. Representative Johnson, you're recognized.
I'm just curious how this changes the current.
Okay. Representative Ashley, would you like to answer that? Would you like to pull? We do have Steve Crump on here and Brittany Lavelle.
I'd
That'd
like
be
to
good.
go out of session and let him answer the questions. Fine.
No, that's fine. Members, any objection to go to session? All right, seeing none. Mr. Crump, welcome. You know the drill. If you would, sir, just be sure your microphone's on and down where we can hear you, and you have 3 minutes. If you'd like to explain something or you just answer questions, it sounds like you have a question for you. So, Representative Johnson, you recognize.
Yes, my question is, how does that change the current statute? What changes made?
Thank you, Mr. Chairman and committee. My name is Stephen Crump. I'm the Executive Director of the Tennessee District Attorneys General Conference. Representative Johnson, it would change currently under second-degree murder. It is an A felony, which would be a minimum of 15 years and a maximum of 25. As a range 2 offender, it would be a minimum of 25 and a maximum of 40. That would mean it is charged or sentenced the same way as rape of a child.
Representative Johnson, any additional questions?
No, that's it.
Very good. Members, anyone else for our guests? All right. Thank you, sir.
Thank you.
All right. Any objection to going back into session? All right. Seeing no, we're back into session. Any additional questions for Representative Ashley? Any objection to the question? All right. So the question's been called. Members, we're voting to send House Bill 1871 to calendar and rules. All those in favor vote aye. Madam Clerk, if you'd open the board for voting. All those opposed vote no. Has every member voted? Does any member like to change their vote? All right. Madam Clerk, if you'd take the vote, please.
Mr. Chair, you have 15 ayes, 0 noes, and 3 present not voting.
Very good. House Bill 1871 is moving to calendar and rules. That'll bring us to item 35. You're still on, Representative Ashley. There, it's House Bill 1542. And you've got a motion and a second. You're properly recognized. That's on House Bill 1542. Item 35, very next bill.
Thank you, Mr. Chairman. I brought this bill after witnessing several times over the summer, people getting frauded, people calling them and having all kinds of their personal information, scaring them. It's happening to every one of us in this room right now. And it's unreal to the extent of what these people go to try to steal people's money. And all this bill does is move, a person commits telecommunication fraud when the person with intent to deprive the owner of property uses a telecommunication device to fraudulently obtain or exercise control over the property of another without the owner's effective consent. This basically moves it from a Class A misdemeanor to a Class C felony is all it's doing.
Members, any questions for Representative Ashley? All right, Representative Powell, you're recognized.
And this might be a question for legal. If I know a lot of times these things happen out of state or even someone's trying to do this out of the country. So I'm curious about jurisdiction and how that would work if they would be able to still be charged in Tennessee, and then how that would that prosecution would move forward. I'm just if we could get out of session, I'd be interested to hear from that.
You're requesting to go out of session here from legal?
Yes.
Members, any objection? All right, seeing none. Ms. Fogarty, you recognize.
Michelle Fogarty, Legal Services. The crime would have to be committed in this state.
Representative Powell?
So if the crime was committed in the state with telecommunications, a lot of time people are sending these messages from another country or another state, as I referenced. In that case, the only way this would be punishable is if the person was doing that and it could be proven that they were doing that in the state of Tennessee. Is that correct?
I believe so, yes.
Okay.
I have Leader Lambert, you recognize, sir.
Thank you, Mr. Chairman. And if I may, just a quick question, legal. Over the years, I believe we passed several different statutes that have established venue in the state of Tennessee when it's certain theft-related or forgery-related offenses because of this type of issue. And so there are, and I'm going to go to legal on this, I believe there are some exceptions to that. As a general rule, you'd have to be located within the state when committing a crime. But obviously with some of these, venue is where the victim is found. And so, but I mean, I think that's kind of spread throughout the code and there's several exceptions. Is that accurate?
Yes, it's just there's nothing about that in this particular bill.
Yes.
Leader? All right, fair enough. Representative Powell?
And not to belabor the point then, so if someone is sending the message in another state or country and the person is receiving it in the state of Tennessee, then can that person be held to a felony if the entire transaction takes place, but they're not here? Or is it the actual, if the device is in the state of Tennessee, they can be held accountable?
That could be a federal offense because it's crossing state lines, but if the defendant is not present in this state, it would be very difficult to prosecute them.
Okay, thank you.
Members, anyone else, any other questions for Ms. Fogarty? Any objection going back into session? All right, seeing none. Any additional questions for Representative Ashley? All right, question's been called. Any objection to the question? Seeing none, Madam Clerk, will you go ahead and open the board for voting? Members, all those in favor of sending House Bill 1542 to Finance, Ways and Means, vote aye. Those opposed, vote no. Has every member voted? Anybody want to change their vote? All right, Madam Clerk, will you take the vote?
Mr. Chair, you have 18 ayes and 0 noes.
Very good. House Bill 1542 is moving to Finance, Ways and Means. Now, if we can just back up to item 24. That's House Resolution 158 by Chairman Bolso. Now, you got a motion and a second. There's no amendments. Mr. Chairman, if you go ahead and just tell us what this resolution does.
Thank you, Mr. Chairman. This is a resolution that constitutes part of the rules package that comes to us from the Supreme Court of Tennessee. As all of you may remember, on an annual basis, the Supreme Court of Tennessee typically issues an order to revise and improve our rules of juvenile procedure, rules of civil procedure, rules of appellate procedures, rules of evidence, and so forth. And this particular bill, House Resolution 158, seeks to revise our rules of appellate procedure in a manner that will enable the public to have greater access electronically to papers that are filed in the appellate court system. It adopts a system, a framework by which confidential information is redacted from briefs and other public filings in the Court of Appeals. And then after having been redacted, the electronic filings are made available through the public access system to the public. And with that, Mr. Chairman, I'm happy to answer any questions.
Thank you, Chairman Bolso. Members, we do this every year. Representative Powell, you recognize.
Just a question, because I'm very cognizant right now of redacted information that's not made available to the public, particularly on the federal level. But what would be the procedure then if the information is redacted? Could elected officials or others be able to view that information?
Chairman Bolso.
Thank you, Mr. Chairman. Well, there'd be a couple of avenues. One, obviously, we've got the Public Records Act, and anyone could bring an action under the Public Records Act to access any information that's been filed with any public entity, including a court system. With regard to the question specifically about elected representatives, Representative Powell, I'm not sure that there's a specific provision in this revised rule that would grant greater access to elected officials than to members of the general public.
Representative Powell, any follow-up?
Just one other follow-up. Who makes the decisions on what information can be redacted and what can't? Who actually does the work on that, if you could?
Thank you, Mr. Chairman. The work is done by the attorneys who actually file the information.
Very good. Any additional questions for Chairman Bolso? All right, seeing any objections to the question? All right. Madam Clerk, if you'd open the board for voting. Members, all those in favor of moving House Resolution on to House Resolution 158 to calendar and rules, vote aye. All those opposed, vote no. Has every member voted? Would any member like to change their vote? Okay, Madam Clerk, you take the vote.
Mr. Chair, you have 18 ayes, 0 noes.
Very good. House Resolution 158 is moving to calendar and rules. And that brings us to item 25. That's House Resolution 159, also by Chairman Bolso. So you're properly recognized.
Thank you, Mr. Chairman. Members, this is the proposed revision to the rules of criminal procedure, and specifically, it seeks to amend Rule 41 regarding searches and seizures. Currently, we have a federal rule that has a nice framework as to how property can be reclaimed from the state if it is unlawfully seized or if it is lawfully seized from a third party in connection with a criminal prosecution. And this revised rule, in particular, Rule 41B, simply adopts the federal system by which property that has been either unlawfully and illegally seized or lawfully seized from a third party to obtain return of that property. In particular, it provides that any person who's aggrieved by an unlawful or invalid search or seizure or by the deprivation of property may move the court for a return of that property. And then the rule goes on to provide the framework for that to happen. And with that, Mr. Chairman, I'm happy to answer any questions.
Members, any questions for Chairman Bolso? Representative Johnson, you recognize.
I'm unfamiliar with how that changes, so could you tell me how that changes what we did at the state level?
Yes, I mean, currently we have in Rule 41 language that deals with how to suppress property that has been obtained through an illegal or unlawful search, but there is no mechanism by which one can obtain return of the property, which has caused some difficulty in the past, which is why the Advisory Commission on the Rules of Practice and Procedure took up this matter, because we had several cases where third parties who were not even charged with a crime had difficulty obtaining their property after a criminal prosecution. We did not have a specifically defined process for that in the Rules of Criminal Procedure, and this revised rule provides that framework.
Thank you.
Very good. Leader Lambert, you recognize.
Thank you, Mr. Chairman, and I want to thank Chairman Bolso for chairing the Rules Commission while this came through. I'm just a member of the Rules Commission, but if I might answer that in a slightly different way, if the police take your stuff and it's related to a case that somebody else is in trouble, not you, it's a quicker way to get your stuff back. So it was a fine answer he gave, Mr. Chairman, but a different spin on it maybe is really what this does. It's I think a very positive change.
As always, the leader is more eloquent than I could ever imagine.
But just short, not more elegant, just more succinct.
All right, Chairman Doggett, you recognize, sir.
Thank you, Mr. Chairman. And earlier today, I was trying to look out into the crowd and I added some air to my chair and it raised me up a little bit. And I seen my friend Donald Rogers sitting over here, a constituent from Lincoln County. So thank you for coming and being with us today. And, Mr. Chairman, I move previous question.
Very good. Members, any objection? Previous question has been called. Any objection to the question? Seeing none. Madam Clerk, if you'd open the board for voting. Members, all those in favor of moving House Resolution 159 to calendar and rules, vote aye. Those opposed, vote no. Has every member voted? Any member like to change their vote? Madam Clerk, if you would, take the vote, please.
Mr. Chair, you have 18 ayes, 0 noes.
Very good. Members, House Resolution 159 is moving to calendar and rules. And that brings us back to the top of our calendar, item 2. Actually, if we could, if we could move to item 4, I've got Representative Leatherwood there, House Bill 1627. Sir, you got a motion and a second. There's no amendments on this bill. You're probably recognized.
Thank you, Mr. Chairman Committee. This is an administration bill to just clean up outdated laws to match current federal law. And the process has already taken place in DHS. Appreciate your support.
All right. Members, question has been called. Any objection to the question? All right. Seeing none. Madam Clerk, if you'd open the board for voting. Members, we're voting to send House Bill 1627 to calendar and rules. All those in favor vote aye. Opposed, vote no. Has ever been voted? And would any member like to change their vote? Madam Clerk, if you take the vote.
Mr. Chair, you have 18 ayes and 0 noes.
Very good. Members,
Thank
House
you.
Bill 1627 is moving to calendar and rules. And if we could, once again, move to item 12, that's House Bill 1668. Chairman Rudd. Sir, you have a motion and a second, and I'm looking at House Amendment 13767. And you have a motion and a second on that amendment. Members, we want to go ahead and adopt that amendment. Any objection? All right, seeing none. All in favor of adopting House Amendment 13767 to House Bill 1668, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. Sir, you're probably recognized.
Thank you, Mr. Chairman. This is the what's called the anti-jugging bill. It gives a little bit more teeth into existing laws when you are following someone from a financial institution or an ATM or any such device with the intent to robbery. As you know, currently under state law, it is assumed that a person who travels with intent to commit theft of another person's cash from a commercial business, financial institution, or automated teller machine on the same path or route of another person would be charged with theft under current law and would not be impacted by the PROS legislation since that's in here, but that's already a part of state law. What this does add is more hefty penalties, and it also gives the police a little bit more leeway in interviewing and stopping people with that intent, and if they're carrying criminal tools, et cetera. And that's what the bill basically does. This bill is supported by law enforcement and the banking industry. It was recently passed in Texas a year ago. And in Texas, where the prominent anti-jugging law became law in September, it now is classified as a felony offense. This has led to increased prosecutionable power, assisted district attorneys, and allows them to act earlier than would otherwise be necessary after the event occurred. So this is giving a little bit more tools and teeth to the police and district attorneys, and it strengthens our laws that's already in place. That's what the bill does.
Members, you heard the explanation. Any questions for Chairman Rudd? Representative Powell, you recognize it. I'll come to you, Representative Johnson.
So you said one thing that concerned me is you said it'll give law enforcement more leniency to stop people. And actually, I think there's a real issue right now with law enforcement stopping people. I've seen this again and again in my district for unjust cause. Quite actually, what they've done has been blatantly illegal. Could you speak to that? Like, what sort of situation would that entail?
Chairman Rudd, you recognize.
No, it wouldn't give them more leniency in that, the police. It would give the district attorney more leniency to prosecute and increase their penalty. They already, under current law, can stop them if they're following someone from a financial institution and question them.
Okay. Very good. Representative Powell, any follow-up? Very good. Representative Johnson, you recognize.
Thank you. So I see, can you give me an example? It sort of defines criminal instrument. So I'm curious, because it could be something that it gives the appearance it could be anything somebody might have in the car. But.
Well, it's if you're following somebody and you're arrested under current law, it could increase the penalty if you have burglary tools or tools that are used with criminal intent. Could be a weapon as well. Could be anything like that. It gives the district attorney more prosecutable power if they're in possession of these tools, or if they have a note, or if it's found that they have a message communications on their cell phone. That can, of course, they already are being prosecuted. They can strengthen the prosecution if they found they have this intent is established to rob someone.
Representative Johnson, any follow-up?
Yeah, because I'm still concerned about what exactly is this. Is it something that could be a normal thing, but you could say it was used as a criminal instrument? Or does it have to be specifically a tool that is no other value except for to break into safes or whatever?
Currently under state law, it defines criminal tools used, like could be like wire cutters, could be other tools that are specifically used. And it could be common everyday tools, but tools that are used commonly for burglary and for robbery, as well as weapons.
So if you were, a landscaper and you had, or for some other reason you were a technical person and you had wire cutters in your car, they could use that, right? Even though maybe that wasn't the intent.
Yeah, Representative Ruddy, any follow-up there?
Well, again, the intent's already been established under current law, that you've already been stopped, you've already been questioned. They're already under prosecution for intending to rob someone and what they found. This gives additional resources and defines the law more clearly so that we can up the penalties of what they're already going to be prosecuted for if they had burglary tools or other type of weapons or tools or a letter or a message to another comrade, a ring, because what we're trying to stop here, the people that follow people from, of course, it could be a homeless person, it could be a drug, someone could be an ex-husband or wife, could be anybody. But the problem here is nationwide. The people that follow people from financial institutions or ATMs, they're usually criminal rings and gangs, and we're trying to clamp down on those. That's what we're specifically targeting.
Yeah, well, and I appreciate that. I mean, I've been in that situation where I'm dropping the bag off, at night in a bank. But I get it, but I'm just a little concerned about what might be considered a criminal implement. But I know what you're trying to get at, and I appreciate that.
Very good. Next, I have Chairman Doggett.
Thank you, Mr. Chairman. So what would be the process for this if someone was to look in the rearview mirror and see that this individual had been following out of the parking lot of the bank or something in a vehicle? They need to call 911, or because I know that law enforcement's not going to be sitting around watching everybody follow you out of a bank to initiate a traffic stop. So I guess there has to be a complaint from the person that feels as if they're being followed.
Chairman Rudd.
That's all covered under current law. If they're following, it usually means that a police officer, a law enforcement officer, has witnessed them following down the street. And right immediately, like they're waiting outside the financial institution and they start following them down the street closely, changing locations, continue. That's what they're prosecuted under current law. This is simply stepping up a little bit more, increasing the penalties if more intent has been established. And that's where if you have notes, messaging from other their criminal ring, like I'm getting ready to follow this one that's got a large amount of money, things like that. This, if they can find that evidence is on them, that they have other criminal intent, that we can up the penalties for the DA to prosecute. It doesn't change current law as far as pursuit or following. That's already in current law.
Chairman Doggett, any follow-up?
Do you know if how many of these have been prosecuted? Do you have any idea on that across I mean, this is obviously an issue. I was just thinking maybe later on it could go into the RICO statute.
Chairman Rudd.
No, I do not know the exact number in Tennessee. No.
Thank you.
All right, very good. Representative Towns, sir, you're the last on the list.
Chairman, excuse me. Thank you. Now, Chairman Rudd, and you're old school, like I'm old school. In your car, I got everything: screwdrivers, wire cutters, crowbars, everything, in case something happens on the road or within the city. Okay. Now, some of these young pups may not, but I travel with everything, cables, everything. Okay. A screwdriver, a lot of wire pliers. A lot of these jokers may not know what a screwdriver is, but I travel with all that stuff in my car, and I always have, and have had to use it too, many times. Chargers that can charge my battery up, so I don't have to call you to come help me out. I can self-charge. Inflators of my tires, all that stuff. Now, any of it can be used in a nefarious way. Any of it can be. And so the question is that, how would someone determine my intent unless I admitted it myself with all that stuff in the car? It's there. It's right there now. How would you determine my intent? I'm not going to admit it to myself or to you or to the police officers unless that's duress. So how do you deal with that?
Chairman Rudd.
I believe it's on your person. If you're carrying tools on your person, not your car. I believe that's how it is currently. And it's also what it said is it also, if you're already arrested for pursuing someone under current law, if you have notes to the ring that you're doing this on your cell phone or a letter in your pocket or tools in your pocket, burglary tools in your pocket or tools used, that's what ups the criminal prosecution's ability.
Mr. Chairman.
Representative Towns.
Good clarification, because I thought it could be in my car and I could be in my car, but you're talking about, I got my little satchel and I get stopped and I have those could be used as criminal tools then, but it's on my person, not in my car, right?
Chairman Rudd.
I would imagine they would have to approve it in a court. A judge and the DA would have to establish. Now, if you are in your car, again, I'm not an attorney,
Right.
and I'm not an expert on the current law. I'm just trying to up give
Right.
more tools and prosecutable power to the district attorneys as well as the police. But I would imagine that, let's say that you were following somebody in your car under current law and they pulled you over and questioned you, and they would have to find intent. They just can't. That right now, if you're closely following someone, they can, I bet you can search your car and vehicle. And if they find something else in your vehicle that's tied into in other words, you said you had a message on your phone, I'm getting ready to follow her and I take her money. And then you had other criminal tools in your car, they could probably use that at that point. But some intent, like a message or a cell phone message to your colleagues in the ring, that would have to be established before you could use anything else other than what's on your person, I am assuming.
All right, very good. Does that answer your question, Representative Townsend?
It does, but Mr. Chairman, follow up with him. If you can, please tell me, currently you can get how much time for it? And then if we enhance it, how much time will a person receive? If you know those.
Chairman Rudd, does this change the time period of classification of the crime at all?
Well, I don't know, Mr. Chairman, I don't know the service times. That's predicted, of course, by a judge, and I don't know the minimum, but it does list, and I can briefly say the four. Class A misdemeanor, a standard violation for following the intent with tools. A Class D felony if a robbery offense is committed during the act. In other words, that ups it. Also a Class B felony if the incident escalates to aggravated robbery, so it's increasing the penalties. And then supporting law enforcement provides specific legal tools to break up the gangs, the jugging gang, and gives tools to the district attorney for prosecution. So it is upping the Class A, Class D, and Class B.
Very good. Well, next on the list, I have Leader Lambert. You recognize?
Yeah, that's what I want.
Move previous question.
Members, previous question has been called. Any objection to the question? All right, seeing none. Members, looks like we're ready to vote. Send House Bill 1668 to, as amended, to Finance, Ways, and Means. Madam Clerk, if you'd open the board. Members, all those in favor vote aye. Opposed, vote no. Has every member voted? Any member like to change their vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 14 ayes and 5 noes.
Very good. Chairman Rudd, House Bill 1668 is moving to Finance, Ways, and Means.
Thank you, Mr. Chairman. Thank
As
you,
amended.
committee.
All right, very good. If we move to item 10, that's House Bill 2253 by Chairman Williams. Sir, you've got a motion and second. You're properly recognized.
Thank you, Chair. Thank you, Chairman members. This is a cleanup bill from last year in regards to language that we adopted last year in Title 39. It does 3 things. It clarifies that an individual cannot possess a firearm under Tennessee state law or court order, and also cannot purchase a firearm. What this language does is, without this change, there's a current loophole that allows some individuals to purchase a firearm in Tennessee, but then could be subject to an immediate arrest for possession of the same firearm. And so this would clean this up, brought to me by the department. So really important that we do that. The bill does a second thing, which was brought, as you know, we're bill limited. So I've got a Christmas tree going on here. So the city of Cookeville reached out to us through our detectives in as it relates to internet crimes, particularly against children. And he was concerned, detective was concerned that the penalties for these images that he and detective district attorneys are having to review aren't high enough. I'll give you an example. Currently under TCA 39, in the sexual exploitation of a minor, a person is convicted of possessing 50 images of a child being raped, can only be charged with Class D felony, gives you 2 to 4 years. You actually, if you get caught with a few Xanax, you get the same thing. And so, secondly, if a person was convicted of possessing 51 to 100 of these same types of images, can only be charged with Class C felony, gets 3 to 6 years, and you get the same 3 to 6 years if you sold hydrocodone pills in the state. If if you're convicted of possessing from 100 to 1,000 of these child rape videos that our detectives reviewing every day, you get 18 to 20 years as a Class B felony. Similarly, a person convicted of 1/2 a gram of cocaine would get the same thing. This tries to increase those penalties. It's going to cost, I know a guy in finance, we're going to try to get it passed, but that's what the bill does. Happy to answer any questions you might have.
Very good. Members, any questions for Chairman Williams? Seeing none, we have Leader Lambert, you recognize, sir.
Thank you, Mr. Chairman. I hear that Finance Subcommittee is a real beast. It's well run, but it's a tough committee to get through. And I do wish you the best, but I want you to look at the board and remember all of those that vote yes today. So,
All right, members, any additional questions for Chairman Williams? Any objection to the question? Madam Clerk, if you'd open the, excuse me,
Just
Chairman
as
Williams, you recognize.
clarification, if I'm not able to do it, even though I'm hopeful that we can, if we're not able to do it, then the first portion of the bill in regards to the loophole will carry through with an amendatory to remove it, because I think it's really important that we do that.
Thank you.
Yep.
Thank you, sir. All right, members. Madam Clerk, if you'd open the board. Members, all those in favor of moving House Bill 2253 to Finance, Ways and Means, vote aye. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Madam Clerk, if you would take the vote.
Mr. Chair, you have 14 ayes, 3 noes, and 1 present not voting.
Very good. House Bill 2253 is moving to Finance, Ways and Means. And that brings us to item 11. That's House Bill 2491. Chairman Williams. Sir, you're probably recognized. I don't see an amendment.
No amendments.
No amendments.
Thank you. Thank you, Chairman, members. This bill was brought to me by the district attorneys. This bill is needed to address the changes regarding the Fraud and Economic Crime Fund and the new implementation of the $12.50 fee for the Public Safety Fund that we did last year. This ensures that once the new $12.50 fund is enacted, duplicate fees and assessments for fraud or economic crimes are no longer collected in that county. So it's a transference from one fee to the new fee of $12.50. This is simply a cleanup from last year's bill, was ensuring that $12.50 fund is enacted in each county, because currently not all counties are doing that. With that, Chairman and members, I'm happy to answer any questions you might have.
All right, very good. Members, we have any questions for Chairman Williams? Any objection to the question? Question's been called. Any objection? Seeing none, Madam Clerk, if you'd open the board. Members, all those in favor of moving House Bill 2491 to Finance, Ways and Means, vote yes. Those opposed, vote no. Has there been voting? Any member like to change their vote? All right, Madam Clerk, if you take the vote.
Mr. Chair, you have 19 ayes, 0 noes.
Very good. House Bill 2491 is moving to Finance, Ways and Means.
Thank you, Chairman. Member.
Thanks, sir. If we could, members, we have item 17, House Bill 1519. I see Representative McCalman there. Sir, you've got a motion and a second. There's House Amendment 13653. Is that something you'd like to move forward with, sir?
Yes, Mr. Chairman, I would.
You have a motion and a second. Members, we want to go ahead and adopt that amendment. Any objection to House Amendment 13653? All right, seeing none, all those in favor vote aye. Aye. Opposed, vote no. Ayes have it. Now we're back on the bills amended. Sir, you're recognized.
Thank you, Mr. Chairman. Good afternoon, members. What this bill does is enact what we're calling the SHARE Act, which stands for Safe Highways and Roads Enforcement. What it does is add a $25 penalty for a standard moving violation, a $50 penalty for a CDL, and $100 for a DUI. Those penalty fees will be allocated to the Highway Fund, and that's all it does. And I stand ready for questions.
Representative Powell, you're recognized.
Thank you. I guess my question here is, I'm all for making sure we fairly ticket people, but I hear from a lot of people in my community that are burdened by these simple costs. So I don't know, can you explain the reasoning why we wouldn't just use this for treatment or, other sort of programs, rather than why would we use this sort of ticket to fund our roads? Seems very strange to me. If you could answer that, please.
Representative McCalman, you're recognized, sir.
Thank you, Mr. Chairman. Representative Powell, simply put, if you're going to break the rules of the road, you can pitch in a little bit more to help pay for them.
Representative Powell, any follow-up, sir?
Yeah, and I guess I'm confused by that logic. I get that, but at the same time, I think the road should be paid for by proper funding that or the people that use the roads, and if somebody is then hit with this ticket, I mean, $25 is a lot of money for a lot of people. It's a lot, and so I think this continues to add up. And I feel like if we're going to continue to increase fees, then and we're using this for highway funds, and we're not doing our jobs as legislators properly funding our roads and our infrastructure. So anyhow, that I see what you're doing. I guess I've got some fundamental philosophical differences with the way we fund our infrastructure. Thank you.
Representative Johnson, you're recognized.
Thank you, Mr. Chairman. And I understand as well, we are 50 billion with a B dollars behind in road projects, but I don't think that adding more to traffic tickets is going to fund the road project. And I have serious problems, as my colleague does, with the use of these monies. And it almost feels like, hey, we're going to add some dollars on here because we're having a problem funding our roads. And I don't think that that is the constituents' problem, quite frankly. I think we need to find a real solution to fund those $50 billion.
Representative McCalman, you recognize, sir.
Thank you, Mr. Chairman. Representative Johnson, I would certainly look forward to working with you in the future on another bill to fund our roads.
Very good. Any follow-up? Representative Johnson.
No, I'm good.
Very good. Representative Travis, I have you next on the list.
Thank you, Mr. Chairman. Call question on the bill.
Very good. The question's been called. Any objection? All right. Seeing no objection, Madam Clerk, if you'd open the board. Members, all those in favor of sending House Bill 1519 as amended to Finance, Ways and Means, vote aye. Those opposed, vote no. Has every member voted? Would any member like to change their vote? All right, Madam Clerk, if you would take the vote.
Mr. Chair, you have 12 ayes, 4 noes, and 0 present not voting.
Very good. House Bill 1519 as amended is moving to Finance, Ways and Means.
Thank you, Mr. Chairman and committee.
Members, if we could, we move to item 20, House Bill 2284. And that, I'm looking, Representative Butler, I'm looking at House Amendment 12956. Is that something you'd like to adopt?
Yes, Mr. Chairman.
Very good. Members, any objection to the question on the amendment? All right, seeing none, all those in favor of adopting House Amendment 12956 to House Bill 2284, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Mr. Chairman. So this legislation was brought to me as a result of having constituents that have farming operations whose fences are being cut. So if you're in an urban district, imagine that you've got a fence around your yard and somebody cuts it to trespass on your property. That's what this bill is meant to address. So we have farming operations that are having their fence cut, and typically side by sides, but it addresses vehicles in general, crossing their property. The farmer comes back a few days later and repairs the fence. And then a few days after that, it's cut again. And they're driving across these farms, tearing things up. And if you've got cattle or other animals that you've got to keep contained, they obviously can escape. And so this bill seeks to address that problem. And it addresses it by imposing a $2,500 mandatory fine on the trespasser and to pay restitution to repair the fence or any other damage they cause for the first offense. And if you're dumb enough to offend again, which I would hope that you would learn your lesson the first time, then you will be imposed with the same $2,500 fine, restitution, and then we would criminally seize the vehicle. And so if you're familiar with some of these side-by-sides, which are the typical offender, some of these things are $40,000 or $50,000. So it's a very expensive, but the damage they're doing and the frustration that they're causing for property owners, I think this seeks to impose a pretty stiff penalty to remedy this problem. With that, Mr. Chairman, I'll be glad to answer any questions.
Thank you for that, sir. Representative Powell, you're recognized.
Thank you. And I'm sure the sponsor knows too, I do represent an urban area, but also have farms in my district. We actually proud to have the Future Farmers of America from my district up here last week. But I do have a specific question because I agree with what you're trying to do here. Do you have to okay, so say some offense is cut. Do you actually have to prove that that person that then trespasses on the property is the person that cut the fence? Because I just want to make sure we don't have a situation where a fence is cut, somebody then drives on that property, is the bill apply? Do you also have to prove that the person that's being punished by this increased penalty was the person that cut the fence?
Representative Butler, you're
Thank you,
recognized.
Mr. Chairman. Well, they're trespassing, whether they cut the fence or not. The whole objective is to keep them off somebody else's property. You know, it's a property right for you or anybody else that owns property to protect that property. So, you know, currently under current law, there's really just a slap on the wrist if you want to know the truth. So whether they cut the fence or not, they still trespassed. Now, I don't know how you would address that, whether they cut the fence or whether somebody else cut the fence. I would still impose a $2,500 fine for trespassing. Thank you, Mr. Chairman.
Very good. Representative Powell, any follow-up? If not, I'm going to go to Representative Johnson. You're next, ma'am.
Thank you. So this is a misdemeanor and it's a $2,500 fine, correct? And in addition to the $2,500 fine for a misdemeanor, they can take your automobile.
Representative Butler.
Thank you, Mr. Chairman. That would be on the second offense. If you're dumb enough after you've been paid the $2,500 fine and restitution and you do it again, then I would hope that most people would learn the first time that they've done this and quit trespassing. So, and let me go a little further. In my district and some of my colleagues' district that represent some of these very, very rural areas, the side-by-side business is multi-million-dollar industry in a lot of these very rural areas. And so in some of my Anderson County district, when the coal industry shut down years ago, a lot of that income for those communities was replaced with the side-by-side business. There are businesses that have been established and started to support that industry, and I support that industry, but I definitely don't support somebody trespassing on somebody's property, and that's what this seeks to address.
But it would also apply in more urban or suburban areas in certain instances, right?
Representative Butler, you're
Thank you,
recognized.
Mr. Chairman. It would, but this is specifically to address a vehicle, not a person.
Very good. Any additional questions? Representative Johnson.
No, I'm good.
Very good. Members, any additional questions for our sponsor? Representative Towns, you recognize?
Mr. Chairman, thank you again. Chairman Butler, so what I understand is that the penalty is not for cutting, the penalty is for trespassing, correct? On somebody's property.
Representative Butler.
The $2,500 is for trespassing. The restitution would be for cutting for the fence or whatever other damage you may cause. Because if, let's just say you're row cropping that particular property and you take a side-by-side through there and damage the crops that are growing, then you've obviously created some additional damage aside from the fence.
Representative Towns.
Mr. Chairman, thank you. So for a lot of urbanites, explain what a side-by-side is.
Representative Butler.
Thank you, Mr. Chairman. So if you're familiar with a four-wheeler, the side-by-side is basically a small motorized vehicle. And some of these things are jacked up, got 3 or 4 foot tires on it. And in Representative Scarborough's district, just outside of my district, is Winrock, which is about a 74,000 acre site that they have trails and so forth. You can pay to ride up there.
Right.
So it's become big business.
Right. So,
And Representative Towns, you recognize?
yeah, so with those big wheels, you could do a lot of damage on somebody's property, couldn't you?
Representative Butler.
Thank you, Mr. Chairman. That is correct. I appreciate you reinforcing that, and I appreciate your support on this legislation.
Thank you very much, sir.
Members, any additional questions? Any object? Representative Salinas?
Yeah, so here for motorized vehicles, I'm reading in section 1 and then 3. It says motorized vehicles, bicycles, electronic bicycles. So those would still be those would be associated with the fine?
Representative Butler, you recognize?
Thank you, Mr. Chairman. They would.
And this applies for urban areas as well, correct?
Okay, Representative,
Thank you, Mr. Chairman. The whole point is to protect somebody's property rights. If you own the property, then it's your right. If you want to let people ride across your property, you also have that right. So there may be folks that own large tracts of land that okay with folks driving across it. But when we have people that don't want you driving across their property, it's their right as a property owner to decide what they want to do with their property.
Any follow-up? Representative Salinas? Seeing none. All right, members, any additional questions? Question's been called. Any objection? Seeing none. All right, members. Madam Clerk, if you'd open the board. Members, we're going to be voting to send House Bill 2284 as amended to calendar and rules. All those in favor, vote aye. Opposed, vote no. Has every member voted? Would any member like to change their vote?
I got it right here.
All right, Madam Clerk, you take the vote, please.
Mr. Chair, you have 15 ayes, 4 noes, and 0 present not voting.
Very good. House Bill
Thank you,
2284
Chairman
is
and committee.
moving, as amended, is moving to calendar and rules. All right, once again, members, we could move to item number 6. That's House Bill 1811 by Leader Lamberth. I'm not seeing any amendments on there, Mr. Leader, so you got a motion second. You're probably recognized.
Mr. Chairman, I hope all of you members have read this bill in full. It is the bulk of the work that we did last year. This is the codification bill. Had we made any amendments to it, we could have wiped out things that we did last year. While we may have wanted to do that at different times, we just try to pass it clean. So it's the codification bill.
Very good. Members, any questions for Leader Lamberth? All right, seeing none. Any objection to the question? All right, seeing none. Madam Clerk, if you'd open the board. Members, we're going to be voting to send House Bill 1811 to calendar and rules. All those in favor vote aye. Opposed, vote no. Does that member vote? Any member like to change the vote? All right, very good. Madam Clerk, if you take the vote.
Mr. Chair, you have 18 ayes and 0 noes.
Very good. House Bill 1811 is moving to calendar and rules. And that brings us back to item 2. That's House Joint Resolution 729 by Leader Lamberth.
Second.
Sir, you got a motion and a second. You're probably recognized.
Thank you, Mr. Chairman, members of the committee. This is the constitutional amendment that we had passed previously. It got hung up behind the budget. They only like to have 3 of these on each gubernatorial election. So if this were to pass, this would move county elections, except for the assessor, to the August-November cycle. So primary in August, regular election, full election in November, and instead of the May-August where it is now. So it cuts down the number of elections per year, saves money, increases voter turnout and everything else. If this were to pass, it would still have to pass the next General Assembly, the 115th, by 2/3, and it would then go on the 2030 gubernatorial ballot for the people to decide.
Well, all right, members, any questions for Leader Lamberth? All right, seeing none. Any objection to the question? All right, seeing none. Madam Clerk, if you'd open the board for voting. We're voting to send House Joint Resolution members 729 to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member want to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 13 ayes, 5 noes, and 0 present not voting.
Very good. House Joint Resolution 729 is moving to Finance, Ways and Means. All right, brings us to item number 3. That's House Bill 1502 by Leader Lamberth.
Second.
Sir, you got a motion and a second. You're probably recognized.
Thank you, Mr. Chairman, and this is the TCI, just update to their statute.
Very good. Members, any questions for Leader Lamberth? Representative Johnson, you recognize.
Thank you. Yeah, just one question. Would this apply to both private and state prisons and institutions? And would it also include juvenile facilities?
Leader Lamberth.
We're not changing what TCI currently inspects. So this would not change. Everything they currently inspect, they would still inspect. It's primarily public institutions. It's jails, not prisons, if that's what you're asking about.
Okay. Well, but so it's not going to include private is what you're telling me, because it already doesn't. Is that what you're saying?
Leader Lamberth.
I'm not aware of any private jails that we have. We have some private prisons that the state contracts with, but this is local jails is primarily what they inspect, and we're not changing anything they inspect currently.
Okay. Do they currently inspect local juvenile facilities?
So, Mr. Chairman, they are here. They've been at every committee, and they've patiently waited and haven't had an opportunity to answer a question.
answer
And
that?
so if you want to have them come up, and these guys are the experts on it, I don't want to misstate what they do every day.
I mean,
That's
if
up to
you,
the chairman.
if you
but-
know, it's fine. I just,
Well,
that's,
it's up to the chairman, but they are here to testify. If, Mr. Chairman, you want to hear from them. Mr. Chairman, I'm sure they can be brief. That's up to you, but.
Leader Lamberth, you'd like for them to come up here, then you, so it looks like we want them up. All right, fair enough. Members, any objection going out of session? All right, seeing none. All right. We're anxious to hear from you this afternoon. Mr. Wall, Lola, and Grisham. Very good.
I'm William Wall. I'm the Executive Director of the Tennessee Corrections Institute. No, ma'am, there are no private jails within the state. This is just updating our statute to get us cleaner with plans of action, to get us cleaner with officer certification and training academies.
I didn't have a problem with the bill. I was just curious about what facilities and did it include juvenile? So do you all do juvenile or
No,
not?
ma'am, we do not do juvenile
Thank you.
facilities.
Very good. Members, any additional questions for our guests? Representative Towns.
So since you're there, explain the difference between jail and prison. On both cases, you're locked down. How do you make the differentiation between the two?
Prisons are for sentenced felons.
Okay.
Jails hold everybody.
Okay.
I mean, from grandma who got a little too intoxicated at the knitting party, all the way to Jeffrey Dahmer. So jails hold a little bit of everybody.
Good deal. Thank you, sir. No, you'll put grandma.
Okay. Leader Lambert, you recognize.
Now, Mr. Chairman, gentlemen, I just want to thank y'all. You've been in every single committee that we've had this bill in, and today is the first opportunity you've had to testify. I just thank you for the work you do, because seriously, it is important that all of our local jails, as well as our prisons, be it public, private, or whatever, that they are safe, both for the inmates and the correctional staff. And it's been a long time coming since we've updated y'all's statute, so just thanks for the work you do.
And thank you, Leader Lambert.
Yeah, appreciate all you do. Members, any additional questions for our guests? All right, seeing none. Thank you, gentlemen, for being here. Appreciate all you do. Members, any objection going back into session? All right, seeing none. All right, question's been called. Any objection to the question? All right, seeing none. Members, we're voting to send House Bill 1502 to calendar and rules. So all those in favor, Madam Clerk, if you'd open the board, vote aye. Opposed, vote no. Has everybody voted? Any member like to change the vote? Madam Clerk, if you take the vote.
Mr. Chair, you have 19 ayes and 0 noes.
Very good. House Bill 1502 is moving to calendar and rules. And that brings us down the list. And Representative Camper has been patiently waiting. Ma'am, I'm going to, item 8, that's House Bill 687.
Thank
And members, if we'll recall, we spent a good amount of time week before last on this bill and had some good discussion. We have already adopted House Amendment 11373 to this bill. So we're picking up from there. So if any member has additional questions for Leader Camper, she'd be happy to answer those, or if you'd like to make any statements.
No, I just want to thank you, Mr. Chairman and committee, for working with me on the bill. Appreciate it.
You worked hard. Members, any questions for Leader Camper? All right. Any objection to the question? All right. Madam Clerk, if you'd open the board. Members, we're going to be voting to send House Bill 687 as amended to calendar and rules. All those in favor vote aye. Opposed, vote no. Has there been voted? Any member like to change the vote? All right, very good. Madam Clerk, if you take the vote.
Mr. Chair, you have 16 ayes and 0 noes.
Very good. House Bill 687 is moving to calendar and rules. Thank you. As amended.
Thank you, Mr. Chairman and committee. Appreciate you.
Members, we can move down to item 14, House Bill 1731. It looks like we have House Amendment 13089, sir, traveling with this. Is this something you'd like to adopt?
Yes.
Very good. Members, do we want to go ahead and adopt 13089, House Amendment to House Bill 1731? All right. Any objections? Seeing none. All those in favor vote, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. This is House Bill 1731. You're probably recognized, sir.
Thank you, Mr. Chairman and committee. This House Bill 1731 involves the removal of objects from sites of burial. If I could, I'd say the practice, problem, and proposal that I am here with today and standing before you as a veteran. Current practice is that veterans may leave an object on a headstone of a deceased veteran, usually a coin. Problem is, people go through cemeteries and rake the coins off. My proposal is that the removal of an item from a spot of burial be included in the code as a part of desecration. And with that, I stand for questions and ask for your appropriate approval of my proposal.
And thank you for bringing this legislation, Representative Wright. Members, any questions on the bill? All right, Representative Johnson, you recognize.
And what is the penalty there?
The penalty would remain the same as it is currently for desecration of a burial site. Let me turn some pages.
Okay, thank you. My colleague back there said it was death, so I'm curious.
I may have turned my pages too quick.
I believe that's a Class E felony.
Yes. The answer is
Class E felony.
Yes.
Thank you.
All right, members, any additional questions for Representative Wright? Any objection to the question? All right, seeing none, Madam Clerk, if you'd open the board. Members, we're going to be voting to send House Bill 1731 as amended to calendar rules. All those in favor vote aye. Opposed, say vote no. Has everyone voted? Anyone would like to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 16 ayes, 0 noes, and 2 present not voting.
Very good. Congratulations, sir. House Bill 1731 as amended is moving to calendar and rules.
Thank you, Mr. Chairman and committee.
And you also have the very next bill. That's item 15, House Bill 1748. And it is amendmentless. No amendments there. So you're probably recognized.
Thank you, Mr. Chairman and committee. That is correct. There is no amendment. This is a bill that has been brought to us by the Tennessee State Court Clerks Association, Mike Hammond, president. It involves access to the indigency fund to pay for interlock devices that people have been sentenced to use by court. It clears up the process by which those funds are accessed, the state treasurer agreeing to the bill. And with that brief explanation, I stand for questions. Ask for your support and passage.
Very good. You've heard the explanation, members. Any questions on the bill? Seeing none. Any objection to the question? Seeing none. Madam Clerk, you'd open the board. Members, all those in favor of sending House Bill 1748 to calendar rules, vote aye. Those opposed, vote no. Has everyone voted? Any member like to change the vote? All right, very good. Madam Clerk, take the vote.
Mr. Chair, you have 18 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 1748 is moving to calendar and rules.
Thank you, Mr. Chairman and committee.
Thank you. All right, members, moving down. Let's move to item 21. That's House Bill 2041. Representative Parkinson, sir, you've been patiently waiting for a very long time. And looks like we have House Amendment 13249 with this. Is that something you'd like to go ahead and adopt, sir?
Yes, sir, Mr. Chair.
Members, is there any objection to adopting House Amendment 13249? All right, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill we're back on House Bill 2041, and we just adopted Amendment 13249. You're probably recognized.
Thank you, Mr. Chair. Chairman and members, there was a private process server in Memphis.
Representative Parkinson, let me just real quick. I have a typo on my page here. That amendment is House Amendment 13429. 13429.
Yes.
So just want to make that correction on the record. You're probably recognized.
Thank you, Mr. Chair. Chairman and members, there was a private process server in Memphis who does evictions and set outs. And when they do when her and her team do the evictions and set outs and putting the property on the curb, they would go live on social media while they were doing it. Thousands would watch, sometimes hundreds of thousands. Sometimes the views hit over 1 million views. People would comment, they would like, they would share, and each eviction would go viral. I personally watched two of the evictions. The first one I saw involved a woman who was clearly in emotional distress or some type of mental health episode. And as you watch that video, lots of people were commenting, sharing, liking. Some people were actually enjoying it and making funny comments. In that video, she wasn't naked, but you can tell that she still had on her bed clothing as they were going live and putting her furniture out on the curb. And this went on for about an hour. And in that process, you could hear the process server herself and the guys that were moving the furniture in and out, going back and forth with this woman in an antagonistic form. And I watched the second video that I watched was kind of along the same lines, but this time it was an 84-year-old woman who lived there by herself, and her furniture was being put out on the curb. And in that process, you could also hear or see on the video rather this senior citizen pleading her case, saying that you know, she wasn't supposed to be getting evicted, that she shouldn't have been getting evicted. And the same thing happened. This one got more views than the previous one, but this one sent the people of Shelby County into an outrage, you know, as they were putting this 84-year-old woman out of her house. And then to make this even aggravated, only later to find out that it was actually an erroneous eviction. But in the process of them going live on social media and getting millions and millions of views, they've taken this eviction and set out process and turned it into an entertainment spectacle that they actually make money off of through the social media platforms. The more views, the more shares, the more likes, the more comments, the more engagement, the bigger the check. And so what this bill does is let me tell you what it doesn't do first. It does not stop a person from recording a set out or an eviction. This bill is only specific to private process servers, not law enforcement. And the bill actually does not even stop them from going live. We worked closely with the Tennessee Apartment Association to get this language. What it does say, it says is this: if you're going to go live, you're going to go live directly to the people who have an interest in what you're doing in the business that you're taking care of.
Representative Parkinson, just hold up one second. Leader Lambert, you recognize.
Move previous question.
Previous question's been called. Any objection to the question?
No, hang on. No, hold up then. Withdraw.
Okay.
We're out of time, so
What's wrong?
just have to wait till another week.
All right, members, and I'm sorry, that's all the time we have for today. So I'll take a motion to adjourn. We'll roll all remaining bills to next available or next calendar next week.